You can be seated. This is the case of the state against Kyle-Rittenhouse, and the appearances are as before. And I sent instructions sometime between 1:30 and 2 this morning, and lest the rumors start that Schrader can't sleep at night. I sleep in shifts, which is actually the normal way to sleep. And I fell asleep during the Blackhawks game, which I shouldn't have. And then I awakened and did my work, and then I went back to sleep. What's going on with those instructions?
Judge, if I could, initially I was hoping that the court would take up our motion for reconsideration, which was filed a week ago Monday.
Right.
And once that's done, depending on how you rule on it, I would have an objection to 2176 because in my reading of 2176, the notes set forth what is to happen or how the court is to do it when there is an alleged exception, which we are alleging here. And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And the response is that I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week. Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to, I looked at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation of the forfeiture action alone, and I can just tell them I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. If it's not the subject for a motion to dismiss, the complaint need not deflect or address every single affirmative defense. And so I believe there's no basis to challenge the complaint to actually get the complaint dismissed. If they wish to present a case, if they wish to raise an affirmative defense, which is that he was compliant under both of those subsections, that if he had a hunter safety permit or the certificate of completion that the second part of that, third part of that statute calls for, they can do so. But until they do that, I don't see why that should be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly will attempt to do so, then it can be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I did not want it to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of the curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
You don't think I can just pick a 12-person jury to decide it?
Well, it's a different standard of proof.
That
confusing. Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause, we've met our standard in the complaint, and it's been bound over. And now it's up to the defense if they want to try and raise this affirmative defense. We disagree that being 17 in and of itself raises affirmative defense. The state believes he'd have to present the certificate of completion of a hunter safety permit as called for in the statute. Thank you.
Okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those. Well, I don't know then that's probably not the best thing to do either, because then they don't know what we're talking about. What's your reaction to the claim that it's an affirmative defense?
It's not an affirmative defense. For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court through the legislative history makes it clear it's an exception. It's not an affirmative defense. It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places it tells you in plain language that it does not apply. Not for hunting purposes, it does not apply, period, to 16 and 17-year-olds who possess firearms. That is, and I've provided that to the court both in the Act and in the Senate bill, Judge, and in the Legislative Reference Bureau information.
Well, I'm going to give the instruction as I've stated it. These are educational. They don't get a written copy, and they're just so they know what we're talking about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which you shouldn't assume. But if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think. I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other, but no matter what it is exceptional from the general language of the statute.
Hey, Judge, I'm not going to argue with you about it. It makes it a strict liability offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
No, unless he has the
No.
safety certificate. That's the last part of the statute. In Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17...
That's how you read it.
Right, not how
He reads it differently.
That's how the DNR reads it. And that's how they cite it.
Yeah, okay.
So in
all
16
right.
and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
well.
And that's being completely ignored in Mr. Trofsky's argument.
Okay. I am going to give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay. And the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't they have a general instruction on self-defense?
You listed them specifically for the charges, or for the counts?
They did?
That's what I saw.
Boy, it was early this morning. It says counts 1 through 5. Oh, no, that's not it. You're right. Let's see, count 5 is attempt to commit murder. That is going to have the same self-defense instruction as count. One, 3, and 4.
Very good. I just wanted to make sure that.
You were correct in your observation.
Well, you tell me when you're ready, Judge.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. Mcginnis. Count 2? Count 2, I'm sorry, 820. Jury instruction 820 is mentioned in there. Mm-hmm. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph, the last sentence says the defendant does not have a privilege of self-defense as to Richie Mcginnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language, and what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the jury to consider in determining whether his conduct was criminally reckless, and also was a factor for them to consider in determining whether it was done with utter disregard for human life. That's how I read it. I certainly don't think I would want to get, you could put a law school test together on this, but that's how I read it. Now tell me where you think I'm in error.
Well, I'm not saying you're in error. I'm saying that I think if he's in self-defense as it relates to Mr. Rosenbaum, according to 820, he then has a perfect self-defense. If the defendant was acting in self-defense, his conduct did not create an unreasonable risk to another. So,
well, wait a minute. Let's give a situation where I'm out on the street and somebody confronts me, and there's a family of 4 little children right behind him, and the other person, the other actor, puts me in, I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone, the danger zone is not only the actor with whom I have a perfect self-defense, privilege of self-defense, but also the 4 children who are behind him. And I think this is how I reconciled that reading in my mind was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless, with respect to those children, and also whether it was showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot wouldn't have the children in the background. That's how I reconciled it. But I agree with you, it's confusing.
Because I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says. So I don't think then.
Well, why do they? I'm sorry. Go ahead.
No. So I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820. The instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then there's a period. So.
Well, why does it say up above that the in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard Mcginnis was lawful.
I agree. That's what I said to you.
No, what you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't, you're telling me there's an absolute privilege of self-defense, not only as to the bad actor, but also as to the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense. That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another. Period.
If you look at the comments from the instructions committee, on page, well, I don't know if you've got the pages there, but well, I have them, but near the end it says, for example, assume that a defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not a, what you're arguing, I think, becomes a perfect self-defense as to injury to others during the exercise of perfect self-defense, and I don't think that's the law. It maybe was what we once thought, but I don't think it's the law now, and that the jury, when they approach the Mcginnis case, looks at whether the defendant, even if exercising perfect self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. Mcginnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. Mcginnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was, if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. Mcginnis. That's how I read it, and that's how I'm going to say it. But I'm going to try to skirt around those fifth, sixth, and seventh counts because we don't have an instruction for number 7, and number 6 is. I've had lots of statutory issues come up over the years, and this is the knottiest. Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me, Jim.
State?
No.
Okay. Let's get the jury down.
Your Honor, before you do that, Your Honor, I do want to put something on the record with regard to the jury.
Oh, yeah, I got something here, too. Yeah, what's up?
Your Honor, at the end of the proceedings last night, Brian Stute from our office came in to begin the process of setting up the audiovisual equipment and whatnot. While he was, I think, entering the courtroom from the hallway, he passed by one of our jurors. And I'm going to identify this juror as juror 52. I can say more about that person's identity, but I don't want to do it openly in court. My understanding is that juror 52 recognized Mr. Stute, said something like, hey, how you doing? Like they knew each other. And I think Mr. Stute responded, politely in response, and that was the extent of their interaction. Mr. Stute has explained subsequently that he had a previous employment where he remembers juror 52 from, and so that's the extent of their prior knowledge of one another. So I wanted to lay that on the record so that everybody is aware of that. I did tell counsel about that this morning before we went on the record as well.
All right. Any question or observation?
Judge, do you feel the need to ask her if that would have any impact on her ability to serve?
I don't. You can ask you can ask me to ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have a question about the accuracy of the report to me. I think it's a non-issue.
That's fine, Judge. We are ready to go forward.
Splendid. Okay, anything else? And I did get a note. Do you know from whom this came? Well, I don't know which one, though.
She didn't put a journal number on there?
Yeah, thanks.
You know you have to kill switch.
Does this only suppress the sound while I hold it down, or does it click on and off? Press. And then if I put, and now I'm live again, right? Okay, I've got the nice hand signals here from the respectful hand signals from the court TV crowd. Thank you.
It's on the back.
I agree with your observation. Okay, you know what? Give them.
I'm guessing.
Okay, well, I guess too, but. Okay, let's ask the lawyers to come up, please. Huh? What did he say?
Sure.
Okay. Make a copy of both sides and then pick it back up, please. All right. I'll wait long enough for that to happen. You know what? You can give it to her when she comes down. All right.
Hello,
Would you come down, please?
you got it.
Thank you.
We need the door open. I don't know if somebody's standing over there or not.
One to a chair, please.
No, we're not using those. We're just using this area. One person can still sit up there. And then push that chair back. Yep.
Oh, okay, good. Thank you very much. We'll give one each side. Okay, there we go. Oh, wait a minute, my response isn't on there. Is my response on the ones you've got there? No. Okay. I give each side, if you can hunt it down, the photocopy of, with my response. Make a copy for each side, and then we'll take care of it. You can be seated. Good morning, everyone.
We'll just one. The gentleman with the scooter.
Okay, and then we have to swear the jury.
Yep.
All right. Maybe you can. The building is almost 100 years old. We're going to have our 100th anniversary, I think, the year after next. And then the chair is original equipment and some of the furniture here. And then can you move that, which is the most comfortable location? Would it be comfortable down there? Right there in front of the officer there?
We'll
Well-
just have to move the chair.
Yeah, well, that might, will he be able to see everything from there? That's my only concern.
Your Honor,
Okay, yeah,
both sides want to put the TV right in front,
okay, perfect.
so, okay.
All right, great. I'll talk more about the building later. And that chair, when there's a break, we're going to move that out of there because I don't think I like it there. Yeah.
Did you fill in the sandwich?
That can go to the, thank you. And then one of these, okay, one of those to each side when there's a break or something. Good morning, everyone, and I'm glad I told you not to come in until 9:45. I did tell you that, didn't I? Oh, okay. All right. No, we were doing some legal stuff, and that happens periodically throughout the trial, and it's nothing exceptional. In fact, it usually ends up saving some time, some of your valuable time, and so we hope Oh, I see how it's laid out. Okay. We hope won't have too much more of that today. Would you? We're going to swear you now your oath to reach a fair and just verdict. So, if you would please,
Can I
Mrs.
ask all
Lehman.
the jurors to raise a hand, please, to take the second oath? Do you and each of you swear that you'll well and truly try the issue joined between the state of Wisconsin plaintiff and Kyle-Rittenhouse defendant, and unless discharged by the court, a true verdict give according to the evidence given in court, so help you God?
And please silence those phones if you would, if you've got them on an audible signal. And before the trial begins, I want to give you some instructions which I hope will help you better understand your functions as jurors and how you should conduct yourselves during the trial. Your duty will be to decide the case solely as the evidence develops, presented at the trial, and the law is given to you in my instructions. Anything that you see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all of the evidence has been presented and I have instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to discuss legal matters with the attorneys that do not necessarily concern you, or in some cases, it's something needs to be discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, which is, it might be a little bit tight, but I think you'll be okay. And otherwise, we may take a break, and you'll be up in your jury room. When you're in the jury room, you need to stay there. You can't be wandering the hallways. You can't be coming and going, except when you have permission from the bailiffs. And you do have, if you have permission from the bailiffs, you may go to the break room across the hall here, where they've got some vending machines. And you can also go outside if you want to get a little fresh air, or smoke if that's what you want to do. The bailiffs will escort you, so you need to go as a group, and they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day. Do not research any information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial. Do not consult dictionaries, computers, websites, or other reference material for additional information. Do not seek information regarding the public records of anyone involved in this case. Any information that you may obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial has been completed, you are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I am not indicating any opinion about the value of that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may rely upon, after the trial, your notes will be collected and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily upon your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice, if any is shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant the third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place the defendant recklessly endangered the safety of Richard Mcginnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male, and to each of these charges as well, the defendant has pleaded not guilty. Reckless endangerment of the first degree, as charged in these counts, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to determine intent, which must be found, if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be Intent should not be confused with motive. While proof of motive is necessary to a conviction, while proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first-degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The sixth count charges that at the same time and place, the defendant was a person under the age of 18 years and was armed with a dangerous weapon. The seventh count charges that at the same time and place, the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts. The first 5 counts of the information allege not only that the defendant committed the crimes which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called upon to answer it, then you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and attempted intentional homicide. A separate instruction applies to, I misstated that. The instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard Mcginnis, the second count, and that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard Mcginnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard Mcginnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard Mcginnis, because Richard Mcginnis was not in any way acting with aggression towards him. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. Mcginnis, who was in the area of the gunfire. And so you have to analyze that separately and determine, well, I'll get further into it. And keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard Mcginnis. If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. Mcginnis showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. We're going to hear the opening statements of the lawyers now. And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement. The argument is for the end, and that's when they're going to make their pleas to you to return verdicts in accordance with their beliefs. At this point, they're going to briefly acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence, and they can be very useful to you for those purposes. And they're brief. And then we can right into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state, and then Mr. Richards will have the opportunity to make an opening statement now, or if he prefers, he is entitled to reserve his opening statement to a later point in the trial. And with that, again, no note, well, you haven't got the papers yet anyway, but no note-taking now because this is discussion by the lawyer. But please give them your attention. And with that, Mr. Binger, you may proceed.
Thank you, Judge. Good morning, ladies and gentlemen. The evidence in this case will show that on the night of August 25th, 2020, here in our community of Kenosha, the defendant, Kyle-Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine. And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man. The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15. The evidence will show that the defendant fled the scene of the dead body of Joseph Rosenbaum without stopping to offer any aid whatsoever. And as he's running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant. One person hits him in the back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber. Eventually, the defendant loses his balance and falls to the ground. An individual who is the subject of count number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face while the defendant is on the ground. This unknown individual is unarmed. The defendant, in response, points his AR-15 directly at this individual as this individual is literally flying over his body and discharges that gun twice. Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe and perhaps even fatal. Immediately after that, Anthony Huber, who is holding a skateboard, comes in and reaches for the defendant's gun. He grabs hold of the gun and tries to pull it away from the defendant. The defendant is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body, and the gun is slung from that, so it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly. A final individual by the name of Gage Grosskreutz has followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand. He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand. The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the photos and the videos, that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand. And as he's reaching for the defendant turns the AR-15 and discharges the 8th and final round into Mr. Grosskreutz's right arm, the arm with the gun. Mr. Grosskreutz runs off, screaming for a medic. The defendant gets up and walks away. On that night, he killed 2 unarmed people, shot at a third at very close range, and wounded Mr. Grosskreutz in the arm, who was armed with a gun. It is the state's position that this evidence demonstrates the criminal charges against the defendant, his intentional homicide of Anthony Huber and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here. As we all discussed yesterday, this occurs during the context of the events following the shooting of Jacob Blake, which occurred on Sunday night, August 23rd, 2020. And we all know that within a short period of time after that, the community erupted in protests, looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street, the furniture business there, Car Source, one of their locations on Sheridan, and other properties around town that were damaged. Fortunately, in the entire sequence of events, this was all property damage. And one of the things we all agreed on yesterday is life is more important than property. Up until Tuesday night, despite all of the things that the community had experienced, no one had been killed. But what happened as the time went on was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community were drawn to the chaos here in Kenosha. People from outside of Kenosha came in and contributed to that chaos. And it caused many of our citizens to fear for their safety, fear for their homes and their families, fear for their businesses, and take steps to protect themselves, whether it is to arm themselves, board up their windows, move, or take time away from the community. All of those reactions were entirely understandable and reasonable. And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue. But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant, Kyle-Rittenhouse. The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle-Rittenhouse. We will show you videos of some of the events that night, of police, tear gas, rubber bullets, and yet the only person who killed anyone was the defendant. There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire throughout our community that night. Hundreds of people are there experiencing this, and yet the only one who kills anyone is the defendant. We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces. And yet the only person who killed anyone is the defendant. Hundreds of people experienced those nights, experienced the night of August 25th, experienced that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle-Rittenhouse. Recently, I heard someone sort of tongue-in-cheek joke that jury service is bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gage Grosskreuz's arm. That will not be in dispute. The central issue in this case is going to be self-defense. And the judge has given you an instruction, which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case. The defendant used deadly force. There is a privilege under our laws to use deadly force, but it's a very limited privilege. That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not with the benefit of hindsight. You are essentially the people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant to believe that the force was necessary to prevent imminent death or great bodily harm to himself? So, let's talk about the context of that evening. And I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence as it comes in this trial. The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th, 2020. In fact, on May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun. And so this was, in effect, a straw purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And they fire both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range that they have on that property. And Mr. Black will tell you some more about that. Then they agreed that that gun would not go home with the defendant to his home in Antioch, Illinois. It would stay here in Kenosha at the residence of Dominic Black's stepfather in a locked gun case. And in fact, after the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th, 2020. On the night leading up to August 25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would do something about what was going on in Kenosha. So at one point earlier in the day, they come down here. They work on cleaning up some graffiti on some buildings here downtown. Then they decide they want to come back later that night and protect a local business, a business called Car Source, which is located at 59th and Sheridan. Now, as I talked to you a little bit about yesterday, Car Source actually has 3 locations very close in this downtown area. One of them was on the east side of Sheridan Road at 58th and Sheridan. And either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out. The building itself was damaged as well. Right across the street from there is another Car Source location that also sold used cars. And some of those cars had been damaged on the night of Monday, August 24th. So on Tuesday, when the defendant and Mr. Black are out and about, they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and the defendant go out to Jelinski's out on Highway 31, Green Bay Road. And they acquire straps so that they can sling those guns around themselves when they come back to the downtown area that night. And eventually, later that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location, and protect that location to make sure no one damages the cars, no one damages the property. And I want to be clear, there's nothing wrong with that. Protecting that property is entirely lawful, totally understandable, and it's something that many people here in Kenosha did. And there's a group of people, including the defendant and Dominic Black, that take up positions at 59th Street. Some of them, like the defendant, are on the ground in the parking lot, where as people are walking by on the street, they're having interactions with these people. Dominic Black will testify he took up a position on the roof. He did that because he didn't want to be on the ground, close to where other folks were, close to where potential issues might arise. He wanted to stay a little bit removed from all of that. Didn't want to get directly involved in it. You will hear and see videos of a sequence of events going on around Kenosha that night. The evening begins with large-scale protests, large-scale, no other way to put it, rioting that's occurring right outside these windows, right in front of the courthouse here at Civic Center Park. There is a crowd of police that have lined up to protect this building, to protect the public safety building, which is right next door. And there are a large number of protesters that are agitating. They are screaming at the police. They are throwing projectiles. Police are shooting rubber bullets, tear gas, etc. It is a very volatile situation at Civic Center Park. Now, that's at 56th and Sheridan, about 3 blocks north of the Car Source where the defendant was. But as the evening goes on, the police decide to move the line of protesters south on Sheridan. And eventually, they pass the Car Source at 59th and Sheridan. The police establish a line at 60th and Sheridan, 1 block south. Now, as that process is going on, many of these protesters pass by the defendant and the people that he's with at 59th Street. Words are exchanged. There is confrontation. There is a little bit of hostility. No one is hurt. No one fires a gun. No one is injured. But clearly there's antagonism. It is clear that this is a crowd that is not on the same side as the defendant, that does not see him as an ally, does not see him and his group as someone that they identify with. And as I said, there is a hostile exchange there for a while. In fact, at one point, members of the crowd pull one of the dumpsters from the property out into the street and attempt to start it on fire. And some of the other folks that are there with the defendant go out and put the fire out and have some very harsh interactions with those people in the street. I believe the evidence will show that it is this process that demonstrated for the defendant that this is a crowd that is not a safe crowd to be in. This is a crowd that does not view him as an ally. This is a crowd that if he ventures out into it, there could be problems. Now, once the police pass by and the protesters are pushed down south of 60th, I believe the evidence will show that the car source that the defendant is stationed at is no longer in danger. There's no one there who's attempting to damage the property. There's no one there who's going to do anything to harm anyone there. The situation has moved on. Does the defendant stay there? Does he decide that he's done what he set out to do and it's time to go home? No. The evidence will show that the defendant and another individual in the group by the name of Ryan Balch, who you will hear from, decide to venture out into the crowd. They cross the police line at 60th and Sheridan, and they walk amongst this group of hostile protesters. At some point, they both wind up at a gas station on the southeast corner of 60th and Sheridan called Ultimate Gas. And you'll see some video of the scene there. It is a scene, again, of groups of people that are clashing with one another verbally. There's some shoving going on. And in the midst of this is Joseph Rosenbaum. And you will hear some testimony about Mr. Rosenbaum and his activities that night. Mr. Rosenbaum had been discharged from the hospital that very day and had come back to his home of Kenosha, had met up with his girlfriend, Carrie Ann Swart. He couldn't stay with her, so he left her and came downtown and got caught up in the midst of these protests. You will see him on videos. You will see photographs of him as he's walking around. He is carrying a plastic bag. Part of that plastic bag is clear and see-through. It has a string, white string, drawstring to it. It is the type of bag, I believe the evidence will show, that you get at the hospital when you're asked to put all of your personal possessions in a bag. Your shoes, your watch, your phone, your jewelry, etc. That's the type of bag it is. And I believe the evidence will show that he was carrying it around most of that evening. And at various points, the evidence will show that Mr. Rosenbaum is agitating. He is getting in people's faces. He is using obscenities. He is essentially daring people to respond. In fact, at Ultimate Gas, I believe the evidence will show that he actually gets right up in the face of armed people who are similarly armed as the defendant, who have similar AR-15 type rifles on. And he is literally confronting them in their faces. None of those folks shoot him. They push him away. He's 5'3", by the way, 150 pounds. They push him away. No one appears to take him as a serious danger. The defendant is at the Ultimate Gas station during part of this, so is Ryan Balch. I believe Mr. Balch will testify that there was an understanding that when we cross south of 60th, we stay together. We try not to intervene in anything. But if we get separated, head back to 59th Street, where our original group is. Mr. Balch does. The defendant attempts to. He comes up to the police line. They won't let him pass. He says, "I work at that business," and points to 59th Street. And again, they won't let him directly through the line. Now, I believe the evidence will show that he could have easily gone a block in either direction if he really wanted to go back, but he turns away from the police line, returns to the Ultimate Gas station. And a few minutes later, we see him on the video of a man by the name of Corey Elijah, who will testify very shortly here in this trial. Mr. Corey Elijah was one of these people out on the streets who was Facebook live streaming the events of that night. And he catches the defendant passing right in front of him with a fire extinguisher. The gun still slung around his body, strapped to his body. And Corey Elijah will testify, this caught his attention. Where's he going with this fire extinguisher? And so Corey Elijah decides to follow with his video, recording the entire way. And we will show you that video. You will see that as Corey Elijah leaves the Ultimate Gas station at 60th and Sheridan and heads south, he passes by the defendant, who by this point is walking, holding a fire extinguisher in his hand, all by himself. Corey Elijah, I don't think registers that that's the person I originally saw, and he keeps on passing him, and as he continues, he passes by Joseph Rosenbaum, who at this point has taken his shirt off. He's got shorts on, and he's taken his shirt and kind of wrapped it around his head. And Mr. Rosenbaum is still carrying that plastic hospital bag and walking down Sheridan towards the 63rd Street car source. The defendant is behind him at some distance. As they get down to the 6200 into the 6300 block of Sheridan Road, that block on the west side of Sheridan has a house right at the corner of 62nd and Sheridan. And then on the south end of that block, the south half, is the car source lot. You will hear testimony from someone from the FBI who was up in a plane that night taking video. And we will show you the video. It is an infrared video, which means it picks up heat. This is at nighttime, so regular cameras, especially from an airplane, aren't going to be able to see everything. So the infrared helps us to see in the dark. The video picks up Mr. Rosenbaum. It is quite clear to see him because he is a white blob. Infrared picks up heat. He doesn't have his shirt on. So the cloth of a shirt would help conceal some of that heat, but when you don't have your shirt on, that heat radiates, and the infrared picks it up more clearly. So he's very easy to see in the video as a white dot. You see him running towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant. As they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said. But what's clear is whatever that confrontation that was initiated by the defendant started, it caused Mr. Rosenbaum to come around the cars and start running after the defendant. The defendant drops the fire extinguisher right there and runs, carrying his AR-15. At some point during that foot pursuit, the defendant turns around, points the gun at Mr. Rosenbaum, who puts his hands up in the air. Now remember, he has got no shirt on. He's got his hands up in the air, almost like, what are you going to do? The defendant stops, pointing at Mr. Rosenbaum, continues to run. And right around this time, there is a gunshot from someone else, who we have identified by the name of Joshua Zeminski. This is an individual who's walking on the sidewalk, probably 30 feet away from where the defendant and Mr. Rosenbaum are running. Mr. Zeminski, for reasons only he can explain, decided to take his handgun and fire it one time in the air. As I said, this is in a different direction and many feet away from where the defendant was. Mr. Rosenbaum continues to pursue the defendant, and we will have Detective Martin Howard testify that he's timed the gap between Mr. Zeminski's shot and the eventual gunshots is about 2.5 or 2.6 seconds. Mr. Rosenbaum closes on the defendant. The defendant turns and fires 4 shots at Mr. Rosenbaum. You will hear the testimony from the Milwaukee County Medical Examiner, Dr. Douglas Kelly, that Mr. Rosenbaum suffered 5 wounds total from 4 bullets. Dr. Kelly will testify that the first 2 wounds that were inflicted upon Mr. Rosenbaum were to his lower extremities. We're not sure which order they were in, but one was to his right pelvis, fracturing his pelvis, and one was to his left lower thigh. Dr. Kelly will testify that these wounds caused Mr. Rosenbaum to start falling face forward. And you will see video of his body where it is found. He lands on his face down on the ground. As he is falling, the defendant fires 2 more shots. One of them hits the defendant in the back, Mr. Rosenbaum in the back. And that is the shot that kills Mr. Rosenbaum, according to Dr. Kelly. You will hear testimony from someone by the name of Richie Mcginnis. Richie Mcginnis is a reporter who came to Kenosha to cover the events of that night. And at some point shortly before these shootings, he encounters the defendant at 59th Street and interviews him. He talks to the defendant and then follows the defendant down Sheridan Road and is right behind the defendant as these shootings are occurring. In fact, he is in the car source lot. He is behind Mr. Rosenbaum when Mr. Rosenbaum is shot. And Mr. Mcginnis will testify that one of those rounds came close to him, which is the basis for the count that we've alleged that Mr. Mcginnis was recklessly harmed or placed in danger by the defendant. Mr. Mcginnis will testify that when he saw Joseph Rosenbaum shot and fall to the ground, he immediately ran up and attempted to treat Mr. Rosenbaum. He took off his shirt. He used it to try and stem some bleeding. He rolled Mr. Rosenbaum over onto his back, and he's attempting to administer first aid. Many other people respond at that very moment to that location and attempt to help Mr. Rosenbaum. They eventually lift him up. They carry him across the street to Frederick South, formerly known as Kenosha Memorial Hospital, KMH, which happens to be right across the street. These folks load him into a hospital SUV that's there in the back of it, and it races off towards the emergency room to try and save Mr. Rosenbaum's life. That's what Mr. Mcginnis does. The defendant, after shooting Mr. Rosenbaum, gets on his phone, calls Dominic Black and says, "I just shot somebody," and starts running away. Now, one of the things that you will see and hear in this case is that the defendant throughout this entire evening held himself out as an EMT, as a medic, that he's carrying a medical bag with him, strapped to his body. And yet, in this time of Mr. Rosenbaum there on the ground, injured, potentially dying, the defendant offers no aid, but instead runs. He runs up Sheridan Road. He encounters another member of their group from 59th Street, who you will hear testify, by the name of Jason Lakowski. Jason Lakowski is similarly armed. He's a former Marine. He had been with the defendant at 59th Street and had come down in response to the gunshots. Mr. Lakowski will testify that he met Mr. Rittenhouse as the defendant was fleeing the scene. And Mr. Rittenhouse said to him, "I didn't shoot anybody, but I need help." And Mr. Lakowski says, "Head up towards the police." So the defendant starts running north on Sheridan. The crowd starts yelling, "That guy, the defendant, just shot somebody," because that's all the knowledge they have at that point. And it's true. So they begin to chase after him. They clearly believe he's an active shooter, and they try and stop him. And I've already described to you the events that followed. Mr. Huber, the unknown individual, and Mr. Grosskreutz. So, when we talk in this trial about the nights of August 25th, we need to keep in mind the context of that night. We need to keep in mind the fact that there were hundreds of people on the street that night, experiencing the same chaos, the same loud noises, the same gunfire, the same arson, the same tear gas, the same hostile confrontations with people who believe the opposite of them. And yet, out of these hundreds of people, only one person killed anyone that night. Only one person shot anyone that night. When we consider the reasonableness of the defendant's actions, I ask you to keep that in mind. Now, in this trial, you are going to hear from a number of witnesses from the state. I've already told you about a few of them. We are going to begin the testimony with Dominic Black, and he will tell you a little bit about the acquisition of those guns. You will hear from Corey Elijah, who was live streaming the events that night. You will hear from Detective Martin Howard, who worked diligently to gather evidence, including many different videos, many different photos of the scene that night. We are going to use that television to show you these things so that you can see them yourself. I know many of you alluded to the fact yesterday that you've watched or read things about this. You will get the full story here in the courtroom, and you will see some things that have not been made public yet. We intend to do that by moving the TV as central as we can so that you can see it as up close and as well as possible. And we will show you as much as we can about the events of that night. You will hear from the FBI individual who was in the plane taking that infrared video that shows the defendant chasing Mr. Rosenbaum and initiating that confrontation. You will hear from other individuals who took video that night. You will hear more about Joseph Rosenbaum from his girlfriend, Carrie Ann Swart. She will tell you about his hospital stay. She will tell you about that bag. She will tell you about what was in that bag. You will hear about Anthony Huber. You will hear that he was a skateboarder, that he lived for skateboarding, that he was at the skate park at Penoya Park all the time, that he actually knew Jacob Blake personally, that he came out that night because he wanted to show support for his friend, Jacob Blake. You will hear what sort of person Anthony Huber was. You will hear from other witnesses who have been affected by that night. You will hear from law enforcement witnesses who did a lot of investigative work to assemble all of the evidence against the defendant in this case. And you will hear from Dr. Douglas Kelly, who will testify regarding the cause of death of Anthony Huber, the gunshot wound to the chest. And you will hear that the shot that killed Joseph Rosenbaum was a shot to the back. And based on all of that evidence, I think you will agree with me that the defendant is guilty of all of these charges. Thank you.
Thank you, Mr. Bingham. Let's take about a 10-minute break. Please don't talk about the case during the break.